Hi everyone, it's Jim Filippi coming to you from the Filippi Law Firm. Today I'm going to talk about objecting to a conservatorship. Now this could be the proposed conservatee, who's the person that someone's trying to get a conservatorship over, or it could be a family member of that proposed conservatee who doesn't think that either a conservatorship is needed or the person that's seeking a conservatorship appointment should be the conservator over that person's affairs. And so it depends on what exactly you're objecting to. When it comes to the actual conservatorship, that's usually fairly cut and dry. Either a doctor has designated that person as being incapacitated, can't care for themselves, and thus needs the conservatorship. And unless there's some sort of, hanky-panky going on with the doctor, it's not something that's typically going to be contested in court. And now, of course, if you get 3 doctors, 3 attorneys, whatever the profession is, you might have some disagreements as to the level of incapacitation. But the reality of it is that if one doctor says they're incapacitated, most likely other doctors are going to agree. Now, I don't want to paint it with that big of a broad brush, but that's usually how it goes. So the way the courts handle an objection deals with what you're actually objecting to. So if you're objecting to the actual conservatorship, the need for such a thing, the conservatee is actually entitled to a jury trial. And everything that goes along with a jury trial will occur during that process. And ultimately the jury would make the decision on whether or not this person actually does need a conservatorship. Now, that's one side of the conservatorship. The other part of an objection could be is flatly that the person that's petitioned to be the conservator shouldn't be the conservator. Maybe a public conservator. There's public neutral fiduciaries that would step in and handle the conservatorship, or maybe there's a family member or a friend or someone else that's more well suited to be the conservator, and so that's what you're objecting to. And in that case, there's no right to a jury trial. Typically the court would make the decision. There's still going to be a trial, but it's what we call a bench trial or a court trial, but ultimately it's the judge deciding on whether or not this person or a number of other people should be the conservator. And that's how that objection occurs. The process is fairly similar to what the actual conservatorship process is. You file an objection, you pay a fee, and you have your day in court. So you really want to make sure that your conservatorship objection is based in reason and in law, because if you unnecessarily and frivolously request a hearing for an objection, you're potentially opening yourself up to paying for the other side's attorney's fees. So you definitely want to speak with an attorney before you get into this situation, because you definitely don't want to end up writing a big check at the end. So consult with an attorney, but ultimately get your conservatorship, your estate planning documents in place so that you personally don't need to have a conservatorship over you. I hope that helped, and I look forward to seeing you in our next video. Take care.